In order to fully experience being a woman has to have cosmetics to put makeup on the face. Otherwise, it's not really the full experience, which is strange. He says, but that is a matter left for another day, whether that be at a later stage of litigation or another case entirely. Wow. So the next step is this is cruel and unusual punishment under the 8th Amendment if the T's don't get their hormone treatments.
How can our system of law survive on those principles, Professor?
I think a system in which there are no meaningful constraints on the president is a very dangerous system
That's
of law.
not what you thought.
A federal judge ordering the transitions to continue. We have this case happening in the District of Columbia and brought by Royce C. Lamberth. We're familiar with this judge because we've covered a lot of cases with him before out of the District of Columbia. He was the same judge, looks like this, about 81 years old, appointed by Reagan a long time ago. And he was terrible on the J6 cases. If you recall, he was the person who handled the QAnon shamans case, and he had some of the longest sentences of more than the 480 people convicted for their actions during the attack. So Lamberth handed down some of the longest sentences that we've seen in all of the cases, and that coming from DC as you would expect. Now today in this decision, he dropped this one, which is basically reversing what Trump did. He's going to give us some background on what happened here. But the T's, who are at the end of the LGBTQs, are now going to be winning on this issue, and this judge is going to be creating this new right for them, essentially, so that Trump cannot stop paying for their transitions or paying for their affirming care or whatever it happens to be. Now, the plaintiffs, writes the judge, in this dispute are inmates in the custody of the Bureau of Prisons who have been medically diagnosed, they say, with gender dysphoria. And during their periods of incarceration, the Bureau of Prisons has provided the plaintiffs with social accommodations like clothing and hair removal devices and all the other things, including hormone therapy, calling this whole thing gender affirming care as a bundle. Now, to mitigate the negative psychological effects of their conditions, Trump issued an executive order which provides that federal funds shall not be spent on any medical treatment for the purpose of conforming an inmate's appearance to that of the opposite sex. So we're not going to pay for it. If you want to, if the jails want to give you a different outfit or something, that's fine. We're not going to pay for all of this. Now, the Bureau of Prisons subsequently promulgated 2 implementing memos to guide the agency's execution of the executive order commands. So the plaintiffs and their access to hormone medications and their social accommodations were then cut off, right? So once Trump issues the order, boom, they're cut. Access to the hormone medications has since been restored, but the plaintiffs remain unable to procure social accommodations. And I guess we'll find out what that means, whatever social accommodations are. So they're getting their hormone meds, so that's happening, but social accommodations, whatever that means. So they have now sued. There's a putative class, they've all bundled together, and they say, we're the oppressed T's, and so we're suing. We want to come together as a bundle and a class. And the Bureau of Prison inmates diagnosed with gender dysphoria, they have moved to certify their proposed class and to preliminarily enjoin the executive order, and this judge, Royce Lamberth, comes out and says, granted, you are now a class, and your motion for the injunction is granted. Background here, January 20th, President Trump came out, issued the executive order. He said, okay, we're not funding the T's anymore. Clothings, anything that doesn't match the biological sex is now canceled. Now, the 3 plaintiffs in this case, T inmates who were diagnosed with gender dysphoria by staff, were in custody at the time that the order was issued, and they're still in custody today. Now, to be transgender, says the judge, is to feel that one is a member of a particular gender that is different from one's sex assigned at birth, which is coming in from this guy, Dr. Dan Karasik. Both gender identity and sex assigned at birth have biological causes. You might have appearance, you might have chromosomes, you might have hormones and other things. And gender identity may also be influenced by other external factors. So they're going to give us a whole lecture on how this disorder works. Now, the plaintiff, this dude called Alicia, is a transgender woman, was diagnosed with gender dysphoria in 2016. Hormone therapy approved to receive social accommodations, including women's undergarments and cosmetics, which actually make you a woman. So this transgender dude, in order to fully experience being a woman, has to have cosmetics to put makeup on the face. Otherwise, it's not really the full experience, which is strange. Now, she was denied her usual hormone shot on 3 occasions and turned back into a dude like overnight. You know, like that scene in Cinderella? What happens when the clock strikes midnight somebody dies or something? So Alicia turned into Alan on January 26th after they missed 1 shot, and then back into Alan again on February 6th and transformed again. And then February 12th again, just like the pumpkin changed, back into pumpkins. All in the same same thing. Unbelievable. The commissary at Kingdom's facility, Alicia Kingdom is my new name, also removed social accommodation items on January 26th. And then once again, Alicia became Alan. On February 4th, Kingdom submitted a grievance. They said, this is ridiculous. I need my hormone treatments so I can go back to my old self. 2 days later, got a response that escalated only with a recitation of the executive order. They just said, here's the order. Read it. It says no. No explanation. Judge was not happy. It says, here's the order. It's in the news. We sent you the paper. Didn't you get it? On February 27th, after the issuance of the first implementing memo, and just 1 day before the issuance of the second implementing memo, Miss Kingdom was informed by a local clinical director that your hormone therapy would not be restored. It's cut off. And that the Bureau of Prisons was receiving new policies. So we're not paying for your hormones anymore. So Kingdom then stated that a discontinuation of the hormone caused Kingdom to experience anxiety and hopelessness and panic attacks and suicidal ideation. Oh no. And no one else in prison is experiencing any of those things. Everything else is pretty much just perfect for everyone else. On March 13th, about a week after this lawsuit, 2 weeks after that, Kingdom had access to hormone therapy restored. The prison avers that Kingdom received an individualized assessment of her prior needs, whatever it was at the time. Kingdom, however, claims that the bureau doctor with whom they met had informed her that the decision to restore treatment had been taken in response to this litigation, and feminine undergarments and commissary items had not been restored. Alicia's not getting tampons, and the judge is going to find this is a violation. We have another person called Solo Nichols, is a transgender man. Wow, okay, so it's an F female to a male. Wow. Who was diagnosed with gender dysphoria in 2021. Yeah. Prescribed hormone therapy in the form of 100 milligram testosterone injections and given access to men's undergarments, men's hygiene products, and chest binders. Then on February 12th, Nichols was given a 50 milligram dose and was informed your next dose is going to be 25. You're getting tapered off, cut in half, and then cut in half again. And then it's going to be discontinued entirely, and you're turning back into Sarah Nichols. Okay, so just get ready. So then on February 21st, Nichols was informed that the testosterone treatment regimen would be re-implemented. It's going to go back to Solo again. Now, the prison claims that this decision was made after an individualized assessment looked at Nichols' needs. But according to Nichols, they said, well, your treatment's only going to be coming in here as long as this restraining order, until the restraining order is up. Now, Nichols further avers that although they met with a prison physician prior to the restoration of the full testosterone treatment, the doctor did not examine him or discuss his mental health or anything. Just walked in and just said, nope, all right, all the T's are now getting your testosterone back jacked up again. So go get your shots so you don't experience your dysphoria. Go get them. Mr. Nichols was informed during the last week of February that he would no longer have access to boxers or chest binders. Those products had not been restored. Yeah, okay. So totally egregious, I'm sure. Now, this is what's happening. Nichols is very scared to live without testosterone therapy because Nichols will lose muscle mass and is going to start menstruating again. Oh, interesting. Because you have a uterus? Is that the one that works through that function? Oh. And likewise maintains that the thought of wearing feminine undergarments, very uncomfortable. Like I can't breathe if I put a pair of panties on. I would feel inadequate and embarrassed if I had to wear panties and my uterus started to function again. Lastly, this other plaintiff called Jas Kapoor. Who makes these names up? Another transgender man, so-called, who began getting hormone treatment and also social and commissary items. Sometime between January 23rd and March 12th, staff informed Kapoor that hormone therapy cut off. Your prescription, as soon as you're done, you're done. So then they sued. They said, well, your therapy is going to come back. His hormone therapy was never discontinued and was told no longer have access to chest binders. The next day, turn in your boxers. You're going to get panties. It's panty time. Now, the Kapoor person fears that the discontinuation of this therapy is going to have the menstrual cycle come back and is going to lead to depression because she has to be a woman. Oh, gosh. On March 17th, the plaintiffs filed for a motion for preliminary injunction. They sued. They said, we're a class action at T's and our rights are being violated here. We have to wear panties. It's ridiculous. The plaintiffs seek relief in form of a stay. They want 2 memos. They want Trump's executive order all canceled. And on the same day, the plaintiffs filed a motion for class certification. Hey, if the gangbangers, okay, the MS-13, Tren de Aragua gangbangers, if they're all getting class certifications, we better get some too. The defendants submitted their opposition to both motions, Trump, and they filed separate replies for the reasons the judge says their action is not barred, right? One of Trump's main arguments was you can't sue us for this. What's your problem? If you want to sue a prison, there's a whole set of laws and statutes you have to follow, and you should do that. And And the judge says, well, they don't have to do that. They can also come into my courtroom. Second, the T's have also demonstrated a substantial likelihood of success on their APA claims, which are these kind of made-up catch-all claims, Administrative Procedures Act claims, and that the court accordingly need not assess the plaintiff's constitutional claims based on the limited record available now. And I think this was mostly the Eighth Amendment cruel and unusual stuff. Third, that the plaintiffs have demonstrated a likelihood of irreparable harm. And fourth, that they're a class. Now, to Roy C. Lamberth's credit, I skimmed through this earlier, and he did go through the whole class certification process, whereas many other judges never even gave Trump the benefit of the doubt on that. So at least he gave a token analysis here. We'll go through it. But he says, in accord with these, this court, Judge Roy C. Lamberth, will now order that there is a class, as modified below, is certified, and class counsel will be appointed. So all the T's will now be a part of a class, and they all are going to get free lawyers and free hormones to become their true selves at your expense. Now, the court will further order that the Bureau of Prisons make available social accommodations as well. All right. So that one dude can get some boxers back to all class members to the same extent they were available, and provide hormone therapy to that one chick who doesn't want her period anymore, to all class members who have been prescribed hormone medications or any other medical personnel to the same extent as before. So now the judges are approving all of the original features that they got under Joe Biden. And so the executive branch cannot run the government according to their intended will. Here's what the judge says. We're going to go through the 4 factors of a preliminary injunction. Who's going to win? Is there going to be irreparable harm? What's the balance of the equities? And is it in the public interest? They say definitely they're a class. Says, well, first of all, they are a class and their claims are not moot at all. Their request for social accommodations is not moot. Okay, so Trump was saying we turn their hormones back on so they can all chill. But all 3 are unable to access their right panties or boxers, which is just critical. Your whole life is over if you get one that was originally prescribed to you. And the others items intended to help the plaintiff conform their appearance to that of the opposite sex, which is, I guess, the belt around the chest. Now, the Kapoor person's request for a continuation is not moot because they keep saying that it's going to be turned off at some point. So none of these things are moot, and they're going to turn them off as soon as this litigation is concluded. So it's not moot, and the judge is going to rule on it. And they weren't required to go file anywhere else. You said that they should have sued if they're upset with the prisons under the statutes that Congress created for those claims, but they don't have to do that. They can sue here if they want. Now, as this court wrote, courts are obliged to hew strictly to the mandatory exhaustion requirement. He's kind of admitting, actually, yeah, you have to go through there, and once you're done there, then you can come to us. But we must apply narrow implicit exception in some instances, which is what I'm going to do here. Now, they say, well, this is not a dead-to-end situation. They should have gone through that other area, and that the BOP is actually giving them their hormones. Now, at a preliminary injunction hearing, the defendants attempted to explain how this reality could be reconciled, and they say, well, actually, what Trump is saying that they're doing to accommodate is not actually accommodating at all. They say in response, the plaintiffs reiterated at the hearing that one plaintiff called Alicia filed an initial grievance requesting access, and she got just a nasty response. It just said, just read the order. And they say, well, that is not, she can't go through the exhaustion process because the process is abusive. Now, therefore, the operative question is not whether they would be required, but whether they can or whether they were required. They already had stuff that was discontinued. And if you take these into consideration, along with the new policies, you don't know whether they're going to end this at any time. So in sum, their challenge to the prison as being unconstitutional and contrary continues. And their filings declare that they have reached an administrative dead end. And so they can proceed here, saying they're also going to win. They say they're challenging the final agency action because this was a final decision that was made by the Bureau of Prisons. They say that these decisions were consummated by Kingdom's final disposition saying that her hormone therapy's turned off. They say, okay, so that is the decision and you've acted and we're challenging this. And they've demonstrated, that the T's say this is arbitrary and capricious. This is ridiculous. It's just like treatment or care for anyone else. You're just attacking the T's, and this is a giant, bigoted, xenophobic thing to accommodate these people with legitimate issues. The APA provides certain standards. Relevant here, agency action may be set aside if it's arbitrary and capricious. And it's like ridiculous that you would ever say that. The government never finds that the government was acting arbitrarily and capricious. The government usually has the right to do basically anything. Let's see what the judge does. Among other possible reasons, agency action may be deemed arbitrary and capricious if it's taken without explanation. There's plenty of explanation. The BOP's memo falls short. The only explanation for its new policies is that the executive order required the adoption of the policies. But as numerous courts have held, well, the fact that you did something is not a good justification for doing something. In other words, you can't have circular justifications. Now, even if the Bureau of Prisons may incorporate the executive order into its own memos, they're deficient. Now, the court takes no position on the goals, but here's what the order says. Here's the goals: to promote dignity, safety, and well-being of women, as well as scientific inquiry, public safety, morale, and trust in government. They want to combat the spread of gender ideology, which is destructive, and the immutable biological reality of sex in favor of an identity-based, inchoate social concept. Now, the court takes no position on this goal. You kind of are. But even if you take it at its face, it has anything little to do with eliminating gender-affirming care. In other words, if you cancel their treatment, how does that actually help you, the government? By taking hormone medications, they're not interested in propagating any particular ideology. They're just experiencing personal anguish. And so we have to make sure they're not experiencing personal anguish by handing them all of these privileges and benefits for their conditions. Now, to be sure, agency action is not arbitrary and capricious just because it's bad for some people. But what you've done here is not shown their own justification, and they need to show more before it's going to be valid. They also say there's going to be irreparable harm. If you don't give them the T's, Alicia is going to turn back into Alan, and it's not going to be good for anybody. The defendants argue that they have not alleged irreparable harm because they're getting their hormones. But it suffices to say that their therapy is at best tenuous. They might lose it. Kapoor says they might lose theirs. And there's other vagaries and vicissitudes in this litigation that you might use to attack these inmates who are receiving this treatment. Now, when Mr. Nichols and Miss Kingdom's access to hormone therapy was restored, there is a likelihood, a possibility that there's going to be an ongoing deprivation. And this is a medical reality. Saying that this is medically necessary, somebody said. So they say it's medically necessary, which means you have to continue to give it to them. Now, the only arguments from the Trump people is that, well, not everybody needs these treatments. And they say, well, some people do. At least some people do need these, and at least some people will be irreparably harmed if they don't get their jabs. So the balance of the equities weigh in favor of the T's. They say, in the case at hand, the BOP says it is providing hormone therapy to over 600 gender dysphoric inmates. Just amazing. Therefore, the defendants cannot even credibly claim that this is going to be a financial burden. They say you're incurring that burden anyways. Well, it's like we'd like to cancel that. That's kind of the point. It's kind of why we're making these changes. They're all getting cut off. Now, the only deleterious public effect on this is you're going to have to continue to pay, but you're already paying, so who cares? We've got a lot of interest in letting this play out. Democracy is not as simple as Trump gets elected and gets, become the president. We're the president too. That's why we have courts, is what he says, giving himself a nice pat on the back. So the court is going to grant the preliminary injunction and certify the class and appoint class counsel all in one fell swoop. So here's the class certification, right? At least the judge did this. Said, okay, there are lots of T's. They're all pretty common and have typical claims. If we certify it as a class, it's going to adequately represent the class's interests. And so it's certified under the rules. And so class action, and Trump is not going to be dismissed as a defendant. And he hates Trump. Says Trump argues that the president should be dismissed because he's immune from injunctive relief. Now, the plaintiffs respond that even though they don't seek to enjoin the president, declaratory relief against the president is still available. And so the court agrees with the T's, saying, I'm going to keep Trump on here so I can make declarations against him. Now, during the pendency of this litigation, the Bureau of Prisons is required to give them their hormones. And moreover, if anybody subsequently determines that they need treatments, you may not take any treatment options off the table while this dispute is pending. So they get mad, like it's like a whole pharmacy now. Actually, I'm going to need that and that and that and that and that and that. Just inject me. The import of the opinion is essentially this. Under the rules, the prison may not arbitrarily deprive inmates of medications or other lifestyle accommodations that its own medical staff have deemed to be medically appropriate without considering the implications of that decision. Even if they did support a decision and the reasoning, its freedom of action may nevertheless be constrained by the 8th Amendment of the Constitution. Wow. He says, but that is a matter left for another day, whether that be at a later stage of litigation or another case entirely. Wow. So the next step is this is cruel and unusual punishment under the 8th Amendment if the T's don't get their hormone treatments. Could be a constitutional problem, but we're not there yet because all their other claims are more valid. So for the foregoing reasons, the T's win and their motion is granted. We'll see if the Trump administration appeals this. I would imagine they do, especially as to the president and the fact that he is still listed as a defendant on here. I'm sure they're going to want to clear that up. So the Trump administration is making clear that they're not going to be endorsing this type of ideology. The other thing they're not going to be endorsing are proclamations for certain months. And here is what Caroline Leavitt said when she was asked about that today.
Does the President have any plans on making a proclamation, or is it just going to be June this year?
Well, there are no plans for a proclamation for the month of June, but I can tell you this president is very proud to be a president for all Americans, regardless of race, religion, or creed.
All right, so no proclamations coming out of the White House this month. Now we're taking a look at people like Roy C. Lamberth. Federal district judges have gone wild. Senator Kennedy is obliterating a professor, contrasting her current statements with prior statements in this beautiful exchange.
Do any of you think that nationwide or universal injunctions are not being abused?
Senator, I'm not sure what the time horizon of the question is. I don't think that there could be good faith disagreements about the correctness of some of them, but I have not seen in the last 4 months abuse. No.
I've read your stuff and I've read your writings, and I don't want to get bogged down with this, but I have little respect for your opinion because I've read your stuff. When someone is in the White House that you agree with and someone gets a universal injunction against him, you don't like universal injunctions.
Of course not.
You called them judges acting like they're politicians in robes and judges looking like crass political actors. But now that President Trump's in the White House, who you dislike, you think that universal injunctions taste like pumpkin pie. So I have to discount what you say because I think you act on your political beliefs. And I worry that that's what you're teaching your kids.
No doubt about it. And her justification for all of this comes out when she gets into it with Senator Josh Hawley. Hawley, of course, is noting what we've been noting and covering here, music to our ears, that there are an onslaught of injunctions that are lobbed against President Trump that just emerged out of nowhere. Their response is always, well, Trump is just extra bad. But when injunctions were issued against Joe, right, the rules, in other words, the tools, the mechanisms are good as long as they decide to use them, which is very convenient of an argument for them. Here is what Hawley said.
Really only once Trump came into office for the first time. You don't think this is a little bit anomalous? You don't think that's a little bit strange?
A very plausible explanation, Senator, you have to consider is that he is engaged in much more lawless activity than other presidents, right?
You don't think
you must
this was
that as a
never used before the 1960s, and suddenly Democrat judges decide we love the nationwide injunction, and then when Biden comes to office, no, actually.
It's Republican appointees as well, Senator, and the 1960s is where some scholars sort of locate the beginning of this, but others,
before then?
Mila Sahoni, who's another scholar of universal injunction, suggests 1913 is actually the first, and others in the 20s.
The Republic endured for 150 years before there was a nationwide injunction.
Well, the federal government was doing a lot less until 100 years ago. So, there's many things that have changed in the last 100 or the last 50 years.
So long as it is a Democrat president in office, then we should have no nationwide injunctions. If it's a Republican president, then this is absolutely fine, warranted, and called for. How can our system of law survive on those principles, Professor?
I think a system in which there are no meaningful constraints on the president is a very dangerous system of law.
That's not what you thought when Joe Biden was
every president
You
is
said that is
constrained
not what
and
you
must
said.
be.
You said
Absolutely.
it was a travesty for the principles of democracy, notions of judicial impartiality, and the rule of law. You also said
the Supreme Court senator agreed 9-0 with me on that.
You also said when Joe Biden was president, you said the idea that anyone would foreign shop to get a judge who would issue a nationwide injunction was just judges looking like politicians in robes. Again, it threatened the underlying legal system. People were just trying to get the result they wanted. It was a travesty for the rule of law. But you're fine with all of that if it's getting the result that you want.
Sir, the Supreme Court agreed unanimously with me in that case, right? There was no standing. The case should never have been allowed to proceed.
Wait,
and the combination of parties without standing and the single-judge division.
No. We're talking. No, they did not. They did not issue a ruling on the nationwide injunction. You criticized the injunction nationwide. Listen,
issued in a case where no one had standing.
Here's the thing.
All right, so you can see it's whatever suits them and their arguments at the current time to achieve their end game and their objectives, which is the right way to be a lawyer or litigator, right? This is why we get so frustrated with the Kilmar case when the DOJ, with the fired attorney, Iraz Ruvani, when he comes out and he just says, yeah, we made a mistake or an administrative error or whatever it is. You use the tools you have in front of you and you use them against your opponent to achieve your objectives at the end of the day. She's a professor. She's obviously sharp. She knows exactly what she's doing. She's a partisan liberal attack person who is explaining both sides of the same issue. This is why when they are used against us, they're bad. This is why when we use them against you, they're good. It's the same argument we've seen repeatedly. But Ted Cruz comes out and he, I think, also responds nicely here, walking us through the fact that these injunctions that are being issued are largely coming out of a certain number of districts. But this is Ted Cruz lacing in to a liberal professor over her biased standards when it comes to federal injunctions.
interesting as our Democrat colleagues defend these nationwide injunctions that neither of them made any reference to the fact that the number of nationwide injunctions issued in the first 4 months is greater than the entire 20th century and is greater than all of the nationwide injunctions issued against Bush, Obama, and Biden combined. Nor did they address the disturbing fact that of the 40 universal injunctions that have been issued in the last 4 months, 35 of them came from the same 5 judicial districts.
Interesting.
There is a reason for this.
Yep.
Blue state attorneys general and radical leftist groups are seeking out affirmatively radical judges who they know will impose their own policy preferences. If it were simply, as our Democrat colleagues said, judges following the law, then you wouldn't have to keep going to the same radical judges over and over and over again, because judges across the board should do that. But the litigants know exactly who the zealots are that are on the bench, and that's who they are seeking out. I will also point out that the discussion about the urgency of protecting the safety of judges. Listen, I agree. We should protect the safety of every federal judge, but it is interesting because my Democrat colleagues were utterly silent during 4 years of the Biden administration when you had violent mobs outside the homes of Supreme Court justices unhappy with the Supreme Court's ruling in Dobbs, and the Biden Justice Department refused to enforce federal law and protect the justices. And my Democrat colleagues were perfectly happy with Supreme Court justices being threatened if they disliked the rulings that were coming from the Supreme Court justices.
Yep, outside Kavanaugh's
Unlike
house.
my colleagues, I believe we should protect judges regardless of whether I agree with them or not. We should protect their safety. And every time you hear a Democrat senator talk about protecting judges from acts of violence, you ought to ask them, why did they not have a word to say about the Biden Justice Department allowing mobs to threaten the families and children of Supreme Court justices night after night after night while Biden's Attorney General refused to follow the law? And with that, I'll recognize...
Because that was Democrat justice. That was social activism. The judges were just hearing from the people. That was free speech rights. And all of these judges who were issuing injunctions against Trump are doing it because they're good people who just honor the Constitution. It's not the idea that they're born in foreign countries who were appointed by Joe Biden, who used to be Canadians 10 minutes ago, and then come in here and say, you're bringing back USAID, like Judge Amir Ali did, or like Judge Chutkan, who comes in and tries to prosecute and incarcerate Trump and then issues injunctions against his executive orders. The list goes on and on. We've covered many of them here, but the judges are part of the legal attack vector that the Democrats have been building for years, which is why they're so hysterical about the ABA losing its special privileges, about all of these mega law firms losing their coveted contracts with the federal government. It's such a loss for them when they can't be embedded with the power structure. And that's why they're throwing a fit about it. And all the judges and their friends and their family members who are getting their NGO money cut off are part of the insurrection. So Ted Cruz, Holly, and Kennedy, we appreciate them calling out these judges. And we're getting ready. We're bracing for a lot more of this because they've got decades of general institutional power that they've built up as Democrats, as lawyers, and we're watching it being executed right now. I think this is really kind of their failsafe here. They've lost everything. So the judiciary is their final stand. We're going to be here covering this and more. Thank you for subscribing and joining as we do.